tomorrow we are supposed to make half day and also day after. But at the same time, I'm told that Dinriano, I manifested to them, I would meet you the whole day tomorrow and on Friday, instead of you staying without a lecturer. But if he would come, then I will yield the time to him. But I understand he's also out of town, because they are heavy scarcity on bar lecturers. Since we are going to meet on convenient hours or extended time, I will meet you only up to 4 o'clock. Tomorrow we can start at 9 o'clock. Then again, end at 4 o'clock. It's too taxing to be meeting for quite a number of hours. Not productive. So let it be our time tomorrow and on Friday. If you have any aspect of criminal procedure that may not be clear to you, write down what that aspect is, and I shall oblige to enlighten you. I'm here to see to it that you learn the right way, and that you would make it in the barita. Otherwise, my sacrifices would be useless, and I might as well retire. On your part, you are also obliged to prove that you learned something, that you can become a lawyer. Otherwise, it may be time to give up. You must have noticed that the first step I took up with you is when a crime is committed and the offender is arrested. The arrest at this stage is a warrantless arrest. Second step is when the arrested offender is brought before the prosecutor's office for preliminary investigation if the crime carries a penalty of no less than 4 years, 2 months, and 1 day imprisonment. Otherwise, the offender may be brought to an inquest prosecutor who will determine whether he should be held in detention or he should be released without prejudice to the filing of a criminal case with the prosecutor's office against him. The third step comes in when, after the preliminary investigation, it is found that there is prima facie case against the respondent. At this stage, where the case is not yet filed in court, the offender is referred to as respondent. Do not refer to him as accused. It is only when the case is filed in court, which will try the case, that he will be referred to as accused. Now, before the case is filed with the prosecutor's office, he is referred to merely as an offender or as a suspect. The correct use of the terms in each stage is important lest the examiner will think that you do not understand what you're talking about. And that will discount the rating that you may have earned. Now, in the third stage, the prosecutor will have to prepare the information for filing in court. The procedure actually is that if the prosecutor who conducted the preliminary investigation resolved that there is a prima facie case to hold the respondent for trial, he will already prepare the proper information and together with his resolution and other evidences supporting the same, the records will be forwarded to the chief or head of the prosecutor's office in that particular office. It is the head of the office or chief prosecutor who approved the filing of the information in court. So if the investigating prosecutor finds that there is no prima facie case, he does not prepare the corresponding information. He will simply elevate his resolution with the records of the preliminary investigation for the chief prosecutor to determine whether the dismissal of the case is proper or the case should be filed in court. You must know by now that no criminal complaint will be dismissed or filed in court without the approval by the chief prosecutor. Now, in the case of investigation conducted by state or regional prosecutor, the approval will be made by the chief state prosecutor. At this stage, where the case is for filing in the proper court having jurisdiction over the case, the remedies against the resolution made by the investigating prosecutor, whether against the filing of the case in court or against the non-filing of the case in court, should be known by you. The remedies against the resolution of the investigating prosecutor. Well, there is a prima facie case, but the investigating prosecutor resolved otherwise, recommending the dismissal of the case and the non-filing of the corresponding information in court. Now, what are the remedies available to the offended party who initiated the complaint? First remedy suggested is to file a motion for reconsideration of the resolution made by the investigating prosecutor. Second remedy suggested is to file a petition for review with the Office of the Secretary of Justice. Now, third suggested step is to file a criminal case against the investigating prosecutor if it would appear clear that he was so biased in refusing to prosecute the respondent, whereas a prima facie case is clear. Under Article 208, Title 7 of the Revised Penal Code, one of the crimes of a public officer is that of maliciously refraining from prosecuting an offender or otherwise tolerating the commission of crimes. That is the criminal offense possibly committed by an investigating prosecutor who, despite the prima facie case, would instead refuse to file a case against the respondent and instead recommended the dismissal of the case. Another suggested step to be taken is to file a civil action against the investigating prosecutor pursuant to Article 27 of the Civil Code. The damages for blatant violation of his official duties. Another step suggested refile the criminal complaint. After all, there is no double jeopardy at this stage. Now, to refile the criminal complaint, there must be at least an added witness for the private complainant to show a justification for refiling the case or include another respondent for the refiling of the case. Whatever be the outcome would not be meaningful instead of allowing the resolution of dismissal to become final. Now, relative to this situation where there is a prima facie case, but the investigating prosecutor resolved to dismiss the complaint and recommend the non-filing of the case in court. This cannot be subject of mandamus. The investigating prosecutor cannot be compelled to file the case in court even though the evidence is clear that there is a prima facie case. This is because the function of an investigating prosecutor is not ministerial, but at least quasi-judicial. It would be different if the investigating prosecutor would simply sit on the case without resolving the same. Now, the remedy of mandamus may be a bill or to compel him to act on the case, but not to compel him to decide the case one way or the other. It is his duty to resolve the case, and that duty he cannot refuse. But it is not his duty to file the case if he believes there is no prima facie case. Nor is it his duty to dismiss the case when the evidence is strongly sustaining a prima facie case. So the remedy may only be invoked if the investigating prosecutor would not want to act on the case. They may be compelled to act on the case, but not to decide it one way or the other. On the other hand, another situation is where prosecutor recommended the filing of the case in court, whereas there is no basis to prosecute either because the law purportedly violated is invalid or unconstitutional, or there is some other reason that may impede the filing of the case in court. While generally a prosecutor cannot be restrained from filing the case in court, regardless of whatever be the probative value of the evidence submitted, the writ of mandamus will not avail. Also, on the contrary, the writ of injunction cannot be availed of to inhibit him from dismissing the case. However, Supreme Court has made several rulings on different grounds already, where a prosecutor may be enjoined from filing a case in court on any of the following grounds. First, when there will be a grave abuse of discretion, so that there is really no prima facie case. Or, secondly, when the filing of the case in court for trial will be tantamount to making use of the strong arm of the law as a means of harassment. Or when the case is filed on the basis of a statute or regulation which is patently invalid or unconstitutional. Or where a prejudicial question is sub judice, and therefore the same must first be resolved. Or when the filing of the case in court would clearly amount to double jeopardy. Or when the investigating prosecutor is not the proper officer to undertake the filing of the recommended case against the respondent. If it is a private crime, there is no complaint, but the prosecutor insists on filing information in court that he can be enjoined, he can be stopped, because that would be an act clearly contrary to law. I've also stated as a ground for enjoining a prosecutor who wanted to proceed with the filing of a case in court, although there is no prima facie case, is where the case result is one of persecution, not a case of prosecution. Or where a motion to dismiss the complaint was filed but denied, notwithstanding the good grounds to give due course to the filing of the case against the accused. In short, there are exceptional grounds where Supreme Court has taken cognizance of situations where a complaint for injunction or a petition for prohibition may be filed against an investigating prosecutor who had recommended the filing of the case in court, whereas there is no such case that merits trial before the court. The case of Broca versus Enrile had cited a litany of cases decided by the High Court which exceptionally allows the remedy of injunction or prohibition to stop a prosecutor from filing a criminal case in court. Ordinarily, this cannot be done because these remedies are not allowed to interfere with the quasi-judicial function of an investigating prosecutor. But where the prerogative of the prosecutor would be abused to a point where there is really no remedy but to stop the filing of the case in court. These situations I have stated are recognized as exceptional situations where the remedy of prohibition or injunction may be availed of simply to question the action of the prosecutor, which may appear to be unlawful or contrary to the administration of justice. These matters have been asked in bar examinations in the past. This case of Broca versus Enrile had been asked in the bar exams repeatedly, and this has been asked for no less than 3 times. The instances when prosecutor may be enjoined from filing a criminal case in court were asked. The legal basis to warrant the filing of the case in court is absent. And with the resolution of the investigating prosecutor, if approved by the head of the office of the prosecutor's office, the information prepared by the prosecutor related to his resolution finding a prima facie case will then be filed with the court to exercise jurisdiction over that case. If the party, whether the complainant or the respondent, filed a petition for review with the Office of the Secretary of Justice, it may happen that the case is already filed with the court, and yet the Office of the Secretary of Justice found differently and therefore directed the withdrawal of the information filed in court, or directed the filing of the information whereas the court already dismissed the case. Now, whose order shall prevail? As far as reviewing resolutions of all prosecuting officers in the government, the Secretary of Justice is the highest prosecutor. So all decisions of prosecuting attorneys shall bow down to the findings of the Office of the Secretary of Justice. On the other hand, where the case is already filed in court, it is settled that the court has already gained jurisdiction over the case, and nobody can decide on whether the case should be dismissed, the criminal case be withdrawn, or that the case should be filed. It's none but the court itself. So on this point, the former practice of filing a motion for reconsideration to the resolution of the investigating prosecutor was filed with the office of the prosecutor until the Supreme Court clarified that no further investigation could be made about the criminal case where an information is already filed in court without the permission of the court where the case is filed. Should it turn out that the information should be withdrawn because the motion for reconsideration had shown that there is no prima facie case, such withdrawal cannot be done against the decision of the court to continue with the trial of the case. Because once the criminal case is filed in court, the discretion of the court will be superior to that of the prosecutor. It is ultimately the court that has to say on whether the criminal case should be dismissed or otherwise should be maintained. The leading case on this is the case of Crespo versus Honorable Judge Judicario Mogul, where upon review by the Office of the Secretary of Justice, it was found out that there is no prima facie case. So the Secretary of Justice directed the withdrawal of the complaint already filed in court, presided by Justice Judicario Mogul. It was a case of estafa, and the judge considered the facts alleged and the affidavits of the witnesses of the complainant that there is a prima facie case, that there is indeed a case of swindling. But the directive of the Department of Justice, by way of the action of the Secretary of Justice on the petition for review, directed the prosecutor's office, which filed the case in court, to withdraw the information filed in the court for that purpose. But the judge does not want to grant the motion to withdraw. So the judge set the hearing of the case. But because there was an order from the Secretary of Justice directing the particular prosecutor's office to withdraw the information already filed in court, the trial prosecutor assigned to the case does not want to prosecute, stating that to do so would be a direct defiance to the order of the Secretary of Justice to withdraw the case. So no prosecutor is willing to handle the prosecution of the case for fear that they may be administratively charged for insubordination. You may have read, incidentally, in this case of then Secretary of the Department of Justice, Mr. Agra, when he assumed the position, he immediately issued an order for the dismissal of the case filed against the Ampatuan. The panel of prosecutors who had somehow acted in building up the case walked out because they have not even evaluated so much the case. And here comes a directive from the head of the office to dismiss the case, whereas they have not even submitted any resolution, whether for dismissal or filing thereof. In other words, the act of the Secretary of Justice then, in the person of Mr. Agra, was purely arbitrary, purely whimsical, without any valid nor meritorious basis. Because of that, they refused to heed the directive to withdraw the case from the court and dismiss the same. And he threatened the prosecutors who would not comply with that order with an administrative charge for insubordination. This is exactly the reason of the prosecutor in that case of Crespo versus Judge Judicario Mogul. Mr. Crespo is now known as Mark Jimenez. He changed his identity after that case of swindling. The judge wanted to proceed with the trial of the case for him to be able to determine whether indeed there is no prima facie case. So he directed the prosecutor to present the evidence in court. But the prosecutor does not want, because he may otherwise be cited by the Secretary of Justice, the highest boss of their office, the prosecutorial office of the government. And so the trial court was in a quandary. No prosecutor wanted to handle the prosecution of the case. So the court wrote to the Supreme Court on this. Supreme Court advised that the court communicate with the prosecutor's office of the Department of Justice, the state prosecutors, and ask for a prosecutor who may undertake the presentation of the evidences on the case. But the court, upon heeding the suggestion of the Supreme Court, could not find any state prosecutor who is willing to undertake the presentation of the evidence against the accused. So this again was brought to the attention of the Supreme Court. Supreme Court suggested, in such a case, the private prosecutor may be authorized to undertake the prosecution of the case. But the public prosecutor should always be present during the trial where the private prosecutor is the one handling the prosecution. This is to comply with the requirement that all criminal cases must be prosecuted in the name of the Republic of the Philippines. And no private prosecutor is legally competent to represent the people or the state. So the public prosecutor should also be there, but the active prosecution of the case be undertaken by the private prosecutor of the offended party. The public prosecutor, if he does not want to handle the case, should not interfere with the presentation of the evidence. But also, the public prosecutor cannot leave while the case is on trial. He should be around, or he'll just sit there while the private prosecutor is the one undertaking the prosecution of the case. Public prosecutor should not leave, otherwise the proceedings will be null and void. Because all criminal proceedings require the presence of the public prosecutor in court, even though he was not the one who will prosecute the case. This requirement is in compliance with the provision of the rules of criminal procedure, that all criminal cases shall be undertaken in the name of the Republic of the Philippines and by the public prosecutor under his control and supervision. That's why he's not allowed to go out of the courtroom and be absent when the private prosecutor is prosecuting the case. On this situation where nobody wanted to undertake the prosecution, the court has to look for one who will prosecute the case. The Supreme Court suggested the private prosecutor to undertake the prosecution, but the public prosecutor should always be there to simulate that the case is being tried under his control and supervision. But supposing there is no private interest involved in the case, so there will be no private prosecutor, then who will prosecute the case? Supreme Court suggested that when the criminal case is already filed in court, the court acquires jurisdiction over the case beyond the authority of the prosecutor to pursue the trial of the case. So Supreme Court suggested that the Department of Justice or the Secretary of Justice should, as much as possible, refrain from entertaining a petition for review when the case is already filed in court, so as to avoid a conflict of authority in the matter of dismissing or maintaining the case. Suggestion of the court, of the Supreme Court, is not realistic, because prosecutors always try to file the case in court before the party prejudiced by his resolution could file a petition for review with the office of the Secretary of Justice. Precisely, they tried to preempt the filing of the case in court by doing this before the opportunity to file a motion for or a petition for review of the decision could be had by the other party. You can never find a case where the party agreed by the resolution of the prosecutor was able to file a petition for review with the Office of the Secretary of Justice, whereas no information has yet been filed in court. It is always done before the party who is aggrieved by the resolution of the prosecutor could file a petition for review with the Secretary of Justice. The information for the crime recommended prosecution by the investigating prosecutor has already been filed in court. And so the suggestion of the Supreme Court cannot really operate. At this stage, where the case is already filed in court, the court will issue a warrant for the arrest of the accused so as to acquire jurisdiction over the person of the accused and the case to be decided upon. In issuing a warrant of arrest, Supreme Court made it mandatory that the court, before issuing a warrant of arrest, should first conduct a preliminary examination of the complainant and the witnesses that he may produce. Preliminary examination is different from preliminary investigation. The variance had already been pointed out by the Supreme Court. In the past bar examination, this matter has been asked repeatedly. The distinction between preliminary investigation and preliminary examination. The points of difference prominently are as follows. One, preliminary investigation is conducted by public prosecutors. While preliminary examination is conducted by the judge of a court before issuing a warrant of arrest. Another point of distinction. Preliminary examination is a proceeding for the determination of probable cause for the issuance of a warrant of arrest. Whereas preliminary investigation is a proceeding for the determination the existence of a prima facie case against the respondent in a criminal complaint, so as to hold him for trial. So one is to determine whether warrant of arrest should issue. One is to determine whether the case should be filed in court for trial. Third point of distinction. Preliminary examination is conducted by a judge, while preliminary investigation is conducted only by a prosecutor. And now judges are not authorized to conduct preliminary investigation anymore. So although the judge conducted preliminary examination of the private complainant and the witnesses he had brought for the court to determine whether a warrant of arrest against the accused should be issued or not. If the crime involved calls for a preliminary investigation, the preliminary examination conducted by the judge is not a compliance with the requirement of preliminary investigation. It does not mean that because the judge already conducted a preliminary examination, the case may be filed directly with the court that will try the case, whereas no preliminary investigation as required had yet been conducted. The two proceedings are entirely different. Where a warrant of arrest was issued, and this can only be issued by a judge. If this was done without preliminary examination, where the existence of probable cause to issue the warrant of arrest was not valued, the warrant of arrest issued is null and void. This is so because when no preliminary examination had been conducted, it would mean only one thing, that the judge did not conduct the required searching inquiry upon the private complainant and his witnesses. On the existence of probable cause for the issuance of the warrant. So this would imply that the warrant of arrest was issued without probable cause. And that would mean the warrant is null and void. On the other, where a case is filed in court without conducting a preliminary investigation, whereas the rules require that the preliminary investigation be conducted, the non-conducting of a preliminary investigation will not invalidate the filing of the case in court for trial on the merits. Instead, the judge will issue an order authorizing preliminary investigation to be conducted if the case requires preliminary investigation, but it was filed in court without the benefit of a preliminary investigation. The importance of one or the other should not be confused. One relates to the validity of the warrant of arrest, the other one does not relate to the validity of the proceeding. Simply that if the preliminary investigation was not conducted, the court may then approve an application by the accused to have a preliminary investigation conducted before the case should be filed in court. In the preliminary examination, the court is required personally to examine the applicant of the warrant and the witnesses that he may bring to court by searching questions under oath or affirmation. If there would be no record of this, then it becomes conclusive that the court issued the warrant of arrest without conducting preliminary examination. So then and there, it becomes conclusive that the warrant is null and void. So this is the way of conducting preliminary examination as dictated by the Constitution and by the rules of court. Well, the judge of the regional trial court issued a warrant for the arrest of an accused. The accused challenged the validity of the warrant of arrest, having been issued without conducting searching questions upon the private complainant and the witnesses that he may produce in court. So, offhand, the accused moved to quash the warrant of arrest on the ground that it was issued without probable cause. When asked to prove this allegation, the accused brought out the records of the court, and there is none insofar as the transcript of records had been jotted down. Now, knowing that our courts are courts of record, anything done by the judge must be taken down by the court stenographer. So there must be graphic notes to evidence the conduct of the proceedings or preliminary examination. So if there is no such transcript at all, it is conclusively clear that the court did not conduct the preliminary examination before issuing the warrant of arrest. Respondent judge, as we shown, to this contention of the accused who was ordered arrested, filed his comment to the motion of the accused to quash the warrant of arrest. The private complainant was required to go over the information. In the information, there is a portion certifying that the prosecutor conducted preliminary investigation, giving the private prosecution, the private complainant, the opportunity to present his evidences. Likewise, giving the respondent the opportunity to present his evidences. The doctor, considering the evidences of both parties, he found the existence of a prima facie case, and that there is probable cause to hold the respondent for trial to answer for the commission of the offense charged. But the Supreme Court took cognizance of the rejoinder by the private complainant that the certification by the prosecutor cannot be capitalized on by the judge so far as the conduct of preliminary examination is concerned, because both under the fundamental law and under the rules of court, for the issuance of a warrant of arrest, the determination of the existence of probable cause must be done by the judge personally. The word personally is there, both under the rules of criminal procedure and also under the pertinent constitutional provision. So when the law says personally, that means nobody other than the judge should conduct the preliminary examination, the evaluation of the evidence. So the respondent judge confirmed that if that would be the explanation, then it would mean that the judge, before issuing a warrant of arrest, should conduct another preliminary investigation, ask searching questions upon the complainant and his witnesses. But the Supreme Court pointed out that this is distorted. It is not required that the judge should issue another preliminary investigation. What is contemplated is that the records of the case under investigation must be forwarded to the court before the court issues the warrant. Whereas in this case, the records of the preliminary investigation was forwarded to the court together with the affidavits of the witnesses of the applicant. It would be only insofar as the preliminary investigation is concerned, but not insofar as the preliminary examination is concerned. The two are different. The certification as to the conduct of the preliminary investigation is by the prosecutor to attest that before he recommended the filing of the information in court against the respondent, the investigating prosecutor had given both the private complainant and the respondent the opportunity to adduce the respective evidences, or the judge to determine whether there is probable cause to file the case in court, not for purposes of conducting preliminary examination. So Supreme Court said these are two different things. Do not confuse preliminary examination with preliminary investigation. What the fiscal conducted or the prosecutor conducted was a preliminary investigation, but without preliminary examination. Since the assail is on the warrant of arrest issued without probable cause, the thing relevant here is the examination of the applicant and witnesses to the issuance of the warrant of arrest without the required asking of searching questions. And it is the judge who, under the law, must conduct this personally to substitute the certification issued by the prosecutor would mean that the determination of the probable cause, which the rules require to be conducted by the judge himself, is violated because the certification appears to have been issued by the prosecutor who conducted the preliminary investigation. There is no showing there that this was established to show probable cause for the issuance of a warrant of arrest. So do not confuse the two. The consequences are different. Now, if the respondent has already been held under detention at the time the case was already filed with the court, which will try the same, the judge of that trial court need not issue a warrant of arrest anymore. The judge will only issue an order of commitment, not a warrant of arrest. And the order of commitment does not require preliminary examination. Preliminary examination is only for the issuance of a warrant of arrest. So if this was conducted for a preliminary examination, then that is proper. to determine existence of probable cause for the warrant, but not to determine probable cause for trial. Regarding preliminary investigation, which is considered as part of due process of law, when there is a law authorizing preliminary investigation before the case is filed in court, and the respondent invokes this statutory right. The jurisprudence here is that to deny preliminary investigation to a respondent who under the law is given that right and who seasonably invoke the right, the denial would be a denial of due process of law. So whatever proceedings the court may undertake after the accused had asked for a preliminary investigation of the case filed against him, and he made the application within that 5-day mandatory period, the court cannot deny the preliminary investigation without denying the accused the benefit of due process of law. So thereafter, whatever the court may do about the case will be null and void, because before that there was already a denial to the accused of due process of law. By itself, preliminary investigation is not part of due process. So where there is no law giving this, the party to a criminal case has no right to ask for a preliminary investigation where there is no law conceding the benefit of a preliminary investigation. It is not part of due process in the sense that preliminary investigation is not provided under the Constitution. But if there was a law which concedes the benefit of a preliminary investigation to a respondent, and the respondent timely invoke the benefit thereof, the court should not deny the application, otherwise the court would be acting without due process of law. So by itself, the preliminary investigation is not a part of due process. But when it's considered by law, there is a law which says that the accused before judge in court must be given the benefit of a preliminary investigation. And the accused invoke this within the requisites prescribed by the rules. A denial thereof will amount to a denial of due process of law. This is the jurisprudence on this. I told you that if the offender was arrested in flagrante for a crime that requires preliminary investigation, since preliminary investigation cannot be conducted within a period of 12, 18, or 36 hours, the rule under Section 6 of Rule 112 requires the respondent to execute a written waiver of Article 126 of the Revised Penal Code. If he would not execute this, he may yet apply for preliminary investigation when the case is filed with the court which will try the sentence. But that application for preliminary investigation is allowed him only within 5 days after he learned of the filing of the information against him. Now, the Supreme Court followed this by saying that the 5-day period allowed the accused to file a motion for preliminary investigation is mandatory. That if not complied with within that 5-day period, the right is lost. And therefore, the court is not duty-bound to allow a preliminary investigation anymore. The denial of that, because the accused did not invoke it timely, would not be a denial of due process of law, because the accused lost the right of his own fault. A denial thereof by the court which will try the case will not be a denial of due process, because the opportunity given under the rules is to ask for this only within 5 days after learning of the filing of the case against him. Understand this deeply. If the accused was already arrested upon commission of the crime, he was arrested in flagrante, so he had been held already. When the case filed in court, the court will not conduct preliminary examination, because what will be issued is not a warrant of arrest anymore, but only an order of commitment. The court will direct the transfer of the accused, if he was held in a place of confinement outside the jurisdiction of the court. So the court will simply direct that that accused or that prisoner be transferred to a certain place specified by the court where the court has jurisdiction. Now, relative to the preliminary investigation under Rule 112, you take note of preliminary investigation in libel cases under Article 360 of the Revised Penal Code. The libel referred to are those written or printed only, not a case of oral defamation or slander. You will recall, under the second to the last paragraph of Article 360 of the Revised Penal Code, it is there provided that the preliminary investigation of written or printed defamation may only be subject of preliminary investigation in the provincial or city prosecutor's office in the capital of the province where the crime was committed. So given a problem where the libel was committed in a certain municipality, there is a municipal attorney there conducting preliminary investigation, and so the criminal complaint for libel was filed with the local municipal attorney. Preliminary investigation conducted by that municipal attorney is conducted without jurisdiction, hence invalid. Article 360 of the Revised Penal Code, in the second to the last paragraph thereof, define which prosecutor's office is competent to conduct the preliminary investigation in written or printed defamation. And under the provision of said article, it is only the provincial or city prosecutor's office at the capital of the province where the crime was committed. Ordinarily, when a crime is committed, the preliminary investigation thereof shall be conducted by the local court where the criminal complaint was filed. But here, you have a different rule. That is why Supreme Court said, in libel cases, the place where the action should be prosecuted is not jurisdictional. Now the third step that will follow after preliminary investigation resulted to a finding of a prima facie case will be the filing of the information with the court having jurisdiction over the crime. What will be filed is the information, because the one who will file this is a public prosecutor, not the offended party nor the peace officer charged with enforcement of the law that was violated. However, if the crime complained of is a so-called private crime, the rules of procedure require that the criminal complaint should be filed by the offended party. In crimes of adultery and concubinage, only the offended spouse. Because the case calls for a criminal complaint to be filed, the filing of the information with the court that will try the case should carry with it the complaint filed by the offended party in the so-called private crimes, so that the court will acquire jurisdiction over that complaint. The filing of the information alone will not suffice. If only the information was filed, the complaint of the offended party was not annexed to the information that was filed in court. So there will be no record that a criminal complaint was filed by the offended party. Now, during the presentation of the case in court, the criminal complaint from the offended party cannot be marked as exhibit if, after all, it was not taken up during the preliminary investigation in the prosecutor's office. And because it was not filed with the information in court, the court will not acquire jurisdiction over the private crime without evidence that the same was initiated by the offended party. although there may be really a complaint filed by the offended party with the prosecutor's office, that is not enough to confer upon the trial court jurisdiction over the complaint, because what was filed in court is the information only. So during the trial, the prosecutor cannot mark as evidence the complaint from the offended party to show that the criminal prosecution is based on a complaint filed by the offended party. So if it appears only to be based on the information, the court will not acquire jurisdiction over the subject matter. In a case where the offended party in a private crime was investigated by the local policeman, and so the policeman, in conducting that investigation of the offended party, conducted this in the form of asking questions, then writing the answers supplied by the witness. It is designated as sinumpaang salaysay, taken on certain date and time, and at the police headquarters stated there. The information was filed, and this was the one annexed to the information. So there is this issue now of whether the court may act on the case filed on the basis alone of an information. There is no complaint. But the private prosecutor confirmed that the sinumpang salaysay is the complaint. Supreme Court ruled that is not a complaint. That is a complaint only for purposes of initiating the case in the prosecutor's office, but not a complaint for purposes of filing it in court. So the complaint referred to under Rule 110 is what you have heard in your study of legal form, almost identical as an information, except that there is a jurat or an oath in the case of a complaint, whereas there is no such jurat or oath in the case of an information. But if the crime subject of the information calls for a preliminary investigation, then at the end of the information there will be a certification, and that certification is required to be under jurat, under oath. But that is not on the allegation of the information. That oath is on the certification that a preliminary investigation has been conducted. So do not consider the oath as part of the information. So these are technicalities that you must be aware of. The word complaint, as known to you in legal form, is not the sinumpang salaysay. It is a complaint in a layman's sense, because by the sinumpang salaysay, the one who gave the statement may be complaining to the peace officers about the commission of the crime. But for purposes of filing in court, that is not the complaint. The complaint is in the substance of an information. So in filing the case in court, the information and if a private crime, the complaint annexed to the information must be filed in court. Section 6 of Rule 110 requires allegations of certain matters to make the complaint or information sufficient. So that must be complied with. Otherwise, the complaint or information would call for an amendment on the ground of insufficiency. You will notice from this requirement that the particular place where the crime was committed need not be stated. What should be stated is simply the place within the jurisdiction of the court where the case is filed. For example, in a case where the crime was committed here in the Palanca Street, before this is known as Ichagi, but it is known now as Carlos Palanca Street, going to Quiapo, to the Quiapo Church, and here ascending the Ayala Bridge. So this was the allegation in the information. Turned out that the crime was committed in Juan Luna, Tondo, which is too far from Palanca Street in Juan Luna, Tondo. That's Divisoria. So the accused filed a motion to quash that the allegation and the information lacks sufficiency, because one of the requirements for sufficiency is the allegation of the place where the crime was committed. The motion to quash was denied. The movement raised this to the Court of Appeals. Same also was denied. So he raised this eventually to the Supreme Court. Supreme Court said the information alleges that the crime was committed in the city of Manila within the jurisdiction of the Regional Trial Court. At the particular place, whether it is at Palanca Street or in the Divisoria, are both in the city of Manila. And the crime committed does not require that the particular place where it was committed be stated because it is an ingredient of the offense. Now, in this case involving a killing, the particular place where the killing was carried out is not an essential element of the crime. As long as the crime was committed in any place within the jurisdiction of the court where the information is filed, that information is sufficient. Particular place is necessary only if it is an element of the crime charged. If, for instance, crime was theft, and what was stolen are these artifacts in the National Library, you will recall that there is a specific article punishing the theft committed in the National Museum or National Library. Penalty is higher because the materials here are of historical value. Article 311 requires the specific place to be alleged, because that is an ingredient of the crime. Penalty is higher precisely because the theft was committed in the National Library or National Museum, and not just before any other place. So the allegation in the information should specifically state that the theft was committed in the National Museum or the National Library, involving the periodical or printed material which is being stored in the National Library. A mere allegation of the crime of theft without stating that particular place renders the information insufficient. If trial proceeded, the accused cannot be convicted under Article 311 of the Revised Penal Code, which punishes specifically the theft committed in the National Museum or National Library. So it will be an ordinary theft where the penalty is based on the value of what was stolen. This is an example where the place where the crime was committed is an element of the crime because the penalty is based on that place. Same is true as to the time the crime was committed. If time was not an ingredient of the crime, the specific time when the crime was committed need not be stated in the information. But if the specific time when the crime was committed is an ingredient of the crime, an element of the crime, then it must be stated categorically, otherwise the accused cannot be sentenced for that crime committed in a particular place or at a particular time. So if the charge was infanticide, the day when the child was born, the day when the killing was carried out, must be specified in the information. Otherwise, a conviction for infanticide will not be practiced. It will just be a conviction for homicide as a generic killing, not for parricide, not for infanticide. Because in infanticide, the victim must be less than 3 days old. Time element is specific. As I said this morning, the more important provision under Rule 110 are those in Section 13, the rule on duplicity of offenses in one information. Those under Rule 14, the rule on amendments in criminal cases, and those under Section 15 on the place where the criminal prosecution should be instituted. On the matter of duplicity of offenses, we have taken up this matter in criminal law relative to Article 48 of the Revised Penal Code on complex crimes. And you have been informed that in those cases where the law prescribes a single penalty for various offenses, it is necessary to allege all the offenses punishable with one penalty in one information only, that the crime should not be splitted and made subject of distinct informations. Because although the crime may be considered as proper or complex, if, however, the prosecutor divided the component crimes into different informations, Article 48, as an exception to the rule on duplicity of offenses, does not apply anymore. As many informations as are filed in court where a specific crime is validly charged, if this would be proven beyond reasonable doubt, the court is under obligation to impose the proper penalty for each crime validly charged and proven in every information. So if there were 5 crimes which should be component of a composite crime, but this was split into different subjects of every information, the court cannot apply Article 48 anymore. Because Article 48 is an exception to the rule against duplicity of offenses. Section 13 of Rule 110. As such, it will only apply when the multiple crimes are charged in one information only. The moment this is splitted, Article 48 does not apply anymore. The situation is not an exception anymore to the rule against duplicity of offenses. Now, you must have learned by now that the fact that an information charges more than one offense, which is prohibited under Section 13 of Rule 110, does not render the information invalid. So if in an information there were 3 crimes stated which do not constitute a complex crime, a composite crime, a compound crime, or a continued crime, it is wrong to consolidate them in one information. So that information suffers from the so-called duplicity or multiplicity of offenses. But that notwithstanding, the information is not rendered invalid. It is only that the accused acquires the right to file a motion to quash, so that the different crimes which are not proper to be joined in one information shall be made subject of separate informations. If the accused did not file a motion to quash, the duplicity is waived. The result, it is tantamount to a situation where each crime was made subject of a separate information. And so, if all the informations were proven, all the crimes were established beyond reasonable doubt, the court will render only one judgment, but that judgment should impose several sentences per every crime charged and proven. If there were 3 crimes alleged in one information, which does not constitute an offense against duplicity, then that information shall be considered as charging 3 crimes. While the accused was convicted thereunder, the court will impose 3 sentences in one decision. The requirement of this under Rule 120 of the Rules of Criminal Procedure is that separate findings of facts and of the law per every crime for which the accused was sentenced must be made in the decision. The only one decision, but there are separate findings of facts as to one crime, separate findings of facts as to another crime, and so with the third crime. And for every crime proven, there will be corresponding penalty for each of them respectively. This is the consequence, but not to invalidate the information just because it suffers from duplicity. Now you get clear that in duplicity, the crimes that were taken up in one information are under the jurisdiction of the same court. The defect is on the information, not on the jurisdiction. But if the duplicity of offenses in one information suffers the fact of jurisdiction because one of the crimes joined in the information is under the jurisdiction of the regional trial court. The other crime joined is under the jurisdiction of the imperial court. But they are joined in one information. So there is duplicity. The motion to quash should not be based on duplicity of offenses as a ground. Because in duplicity of offenses, the jurisdiction over the crimes which are taken up in one information must be with the same court. It is only that the information charges more than one offense in one information which is not allowed because the situation is not an exception to the rule against duplicity. So if one of the crime joined is under the jurisdiction of the regional trial court, the other is under the jurisdiction of the imperial court, you are asked, is there duplicity of offenses? There is none. Because the 2 crimes are under different jurisdiction of the court. So if a motion to quash should be filed, it should not be filed on ground of duplicity of offenses. The motion to quash should be on the ground that the court has no jurisdiction over the crime charged, and you have to specify that crime which is not within the jurisdiction of the regional trial court. Now this you may encounter. This is the tricky aspect of duplicity of offenses. There are 2 offenses charged, but that is not duplicity because the court has no jurisdiction over the other. And therefore, whatever the court would do on that other crime is null and void. It is non-existent because it is a matter of jurisdiction over the subject matter. Do not fall into this error. When this contemplated examiner in this year's bar exam, either remedial law or criminal law, was the chairperson of the bar exam, this was a problem given by me. And modestly aside, he told me, "You are the only one who got the answer correctly." All the answers were wrong because they relied on the supposed Section 13 of the Rules of Criminal Procedure. There is no duplicity because one of them is null and void. When jurisdiction is on the subject matter, everything that the court will do about that invalid. There is no duplicity. You may encounter this again. On amendment, Section 14 primarily considers amendment in criminal cases as to whether it is an amendment of form or an amendment of substance. The information may be amended both as to form and substance if the amendment would be made before the accused was arraigned and before he had entered a plea during that arraignment. So before arraignment, amendment is allowed as a general rule on matters of form as well as on matters of substance. Once the accused had been arraigned and he had entered a plea already, whether of guilty or plea of not guilty, amendment as to substance is not allowed anymore after arraignment and plea of the accused. Only amendment of form is allowed. And this is allowed only if the amendment could be done without prejudice to the substantial rights of the accused. Hence, before the information was subject of an arraignment and the accused has not yet entered a plea, the amendment, both in form or substance, is a matter of right. But if the amendment would be done after the accused had been arraigned and had entered the plea, only amendment of form is allowed. And only if the amendment of form could be done without causing prejudice to the substantial rights of the accused. There is, however, an exception now engrafted to this rule on amendments under the revised rules of criminal procedure. That although the accused has not yet been arraigned and has not yet entered a plea. Amendment, which is otherwise a matter of right, shall not be allowed if the amendment either, one, downgrade the crime charged in the original information. So if the amendment would be to lower the crime from murder to homicide, the same cannot just be made without prior leave of court. Because the amendment which downgrades the gravity of the crime charge cannot be done as a matter of right. So whether before or after, this requires prior leave of court. Second kind of amendment is where one of several accused charged in the original information shall be dropped from that information. This was not here before. Before, it's only a matter of whether the amendment is before the accused was arraigned and had entered the plea, or it was after the accused had been arraigned and had entered the plea. But because of the rampant corruption on this, an express prohibition is made that the amendment cannot be made without prior leave of court, because this was the way of trading between the prosecution and the accused on whether the crime would be downgraded or that one of several accused who can afford to pay will simply be dropped from the information. This became then subject of corrupt negotiations. And so it is now prohibited. And if efforts to make this amendment would be done, this cannot be done orally. You will notice the rule requires a notice of hearing. So that means the motion or leave of court must be in writing. And the notice of hearing should be served to the private offended party, precisely to afford him the opportunity to object to the amendment. But if he was notified, he did not appear, then whatever was done that brought about the amendment, he cannot question the same anymore. Whatever question he has is considered waived. The problem actually for you to determine whether the amendment is one of form or one of substance. In the case of Tihamki versus Judge Madaya, then of Makati, in this killing of the girl Maureen Holtman, initially the criminal case was for frustrated murder because the victim was still alive. Although the courts, or rather although the decisions were announcing that the condition of the victim was constantly improving, and therefore hope of her recovery is in sight. Yet, it soon happened that complications developed and the victim died. So instead of a case of frustrated homicide or frustrated murder, the crime becomes consummated murder. The prosecution then moved for the suspension of the trial to allow it to amend the information because the victim had already died. The defense and the accused vehemently objected to the announced amendment, and they confirmed that since the prosecution had already presented two witnesses whose testimonies are already completed, the accused is not only arraigned and had entered the plea, but trial already began. So, the amendment, which is an amendment of substance, should not be allowed anymore. The trial court, however, granted leave to amend. And so the case was suspended for trial to allow the prosecution to file an amended information, this time charging the accused for consummated murder. The accused vehemently objected to this, and because the trial court allowed this, a petition for certiorari was filed with the Supreme Court. Great abuse of discretion, amounting to an exercise without jurisdiction, because the law prohibits any amendment of substance after the accused had already been arraigned and had entered a plea. But the crucial question is not just the nature of the amendment or the time when the amendment is to be made. The crucial question is it an amendment of substance or is it an amendment only of form? Contention of the trial court, it is only an amendment of form. Contention of the accused or the defense is that it is an amendment of substance, because penalty for frustrated murder is different from the penalty for consummated murder. Penalty for consummated murder is much higher than the penalty for frustrated murder. So the contention of the defense appears to be more meritorious. But analyzing this, is that really an amendment of substance? You take it in this light. From the viewpoint of a layman, it is an amendment of substance, because the amendment would bring about an increase in the penalty. From frustrated murder is 1 degree lower, from consummated murder it goes up by 1 degree higher. Penalty would not have been there for frustrated murder. The moment it's amended to consummated murder, penalty of death becomes impossible. But for purposes of determining whether the amendment is one of substance or one of form, you consider whether the amendment would place the accused under double jeopardy. If the amendment would place the accused under double jeopardy, then it is regarded in criminal procedure as an amendment of substance. But if the amendment would not place the accused in double jeopardy, then in criminal procedure is regarded only as an amendment of form. Because of the exceptions in the last part of Section 7 of Rule 170 on motion to quash and on double jeopardy under said Section 7, when a greater offense develops out of superseding facts arising from the same act or mission subject of the original information, there is no double jeopardy. Because there is no double jeopardy, because this exception is now made part of the rule, the amendment to bring about a greater crime that developed out of superseding facts, the complications that happen, the superseding facts to the facts constituting the original information, the amendment to bring about the superseding facts for a greater offense is not an amendment of substance. It is regarded only as an amendment of form because that amendment will not expose or subject the accused to double jeopardy. We will take up some other cases to bring out this fact that if the amendment would expose the accused to double jeopardy, it is an amendment of substance. If not, even though the substance of the original information will be totally overhauled, it is only an amendment of form. So you do not react on this in an ordinary English of what is substance, what is form. This is a procedural concept of when it is of substance, when it is of form. Do not inject your layman's understanding of this. Let us end here. Anyway, we will be meeting all day for 2 more days. I will discuss with you what you cannot just read from the provisions of the rules. And if there is any aspect that is not clear to you, write them down so I can lead you to how to react to the situation you may have perceived. So let us end this. We begin tomorrow at 9 o'clock. We end 4 o'clock. Until tomorrow then. Good day to all of you. May God bless you.